Andrea, how you doing?
Rob is not in the room. Here, hold on, I'm gonna put it on speaker so I can go type and see. Hey, Andre, do you hear the typing noise? And is there static?
Should be good. Sorry, Rachel, talk to me 1 second.
Hear the typing?
No, it's good.
Okay, perfect, thank you.
Great, thanks.
Hey.
Welcome to the monthly webinar presented by Pro Bono Partnership of Atlanta. We want to begin by thanking Georgia Legal Services for hosting the webinar and making it available on its website. My name is Richard Reimer, and I'll be talking about the truths and myths of trademarks and copyrights. The mission of Pro Bono Partnership Atlanta is to provide free legal assistance to community-based nonprofits that serve low-income or disadvantaged individuals. They match eligible organizations with volunteer lawyers from the leading corporations and law firms in Atlanta who can assist nonprofits with their business law matters. To be eligible to be a client of Pro Bono Partnership of Atlanta, you have to be a 501c3 organization, nonprofit organization, be located in or serve the greater Atlanta area, serve low-income or disadvantaged individuals, and be unable to afford legal services. You can visit them on their website at www.pbpatl.org. Also, while you're there, be sure to look at the workshops page to see other upcoming webinars and workshops. As you may know, trademarks and copyrights are types of intellectual property. I'll discuss trademarks first, including an overview, protection, ownership, common myths, and a hypothetical as well. Then I'll do the same thing with copyrights. I'll try to leave time for questions at the end of each section. Feel free to submit your questions along the way. Trademarks are source identifying symbols which allow the public to quickly determine the maker of the good or the provider of the services. These source identifying symbols can be words, symbols, slogans, colors, trade dress, sounds, and much, much more. Some common examples are the words Coca-Cola, the contour shape of the Coca-Cola bottle, the Nike swoosh, Home Depot slogan, more saving, more doing, the color orange used by Home Depot, and also the NBC chimes. There are some things that cannot be trademarked. These include functional features, descriptive terms, geographic names, generic names, and misleading names. There's one caveat to this, that descriptive terms, geographic terms, and misdescriptive names can become registered after they achieve what's known as secondary meaning, which means that the public begins to understand that the Kentucky Fried Chicken store is not just any store selling Kentucky Fried Chicken, but a very specific provider of fried chicken that's known as Kentucky Fried Chicken. Turning now to slide 5. Trademark rights entitle an owner to exclusive use of a mark in connection with the underlying goods and services. For example, many of you are probably familiar with the fact that Starbucks recently started selling instant coffee under the trade name Via. Starbucks now has enough rights to prevent other companies from using very similar names in connection with very related goods and services. Trademark rights in a mark begin to accrue once these are used in commerce. However, these rights can be enhanced via registration. Unregistered marks are usually referred to as common law, or you have common law rights in a mark. Going back to the Starbucks example, Starbucks has the right to stop others from using the mark Via in connection with instant coffee or related services only where Starbucks is sold. Now that's not much of a limitation for Starbucks possibly, but for a lot of mom and pops who only have a location here or there, that's not a lot of protection. So a federal registration or any registration will expand the rights to the entire jurisdiction. They'll establish evidence of the validity of the trademark and also the knowledge of the ownership of the trademark, and in many instances can treat the owner as using the mark at an earlier date and time, which you'll see can be advantageous. A lot of my pro bono clients say that the $325 charged by the U.S. Patent and Trademark Office is often prohibitive for them to apply for federal trademark registration. I advise many of those to look at the state registrations that are out there. A state registration is very inexpensive. For example, in the state of Georgia, the application fee is only $15. Other states have similar low amounts, so it may be worth considering a few state registrations when a federal registration doesn't seem manageable. The test for infringement is likelihood of confusion. Now, likelihood of confusion is pretty much as it sounds. It tests whether or not the public is likely to be confused between two marks. So in the VIA example, if some other product comes along and Starbucks is concerned that the other mark is infringing their rights, the courts will look to see whether there's a likelihood of confusion between Starbucks' use of VIA with instant coffee and this junior user's use of whatever mark with their goods and services. The primary things that courts look at in a likelihood of confusion test are the similarity of the marks, that is the sound, sight, and meaning of the marks that are being compared, and the relatedness of the underlying goods or services. A few other things are also very important. There's a whole list of elements that can be looked at, but a few I'll mention to you are the fame of the prior mark, and whether or not there's been any actual confusion in the marketplace between the two marks that are being compared. However, as with many factor tests, this is much more of an art than a science. So what I'd like to do is to illustrate likelihood of confusion. I have 5 different court cases here where courts have looked at 2 different marks to see whether or not there's a likelihood of confusion between these 2 marks. In the first example I have, Teflon, the owner of the mark Teflon used in connection with non-stick coating, was suing for infringement the owner of the mark Teflon, who also was selling non-stick coating. As you can see, the goods and services are identical. The sound and sight of Teflon versus Teflon are very comparable, and as you might expect, the court found that yes, there was a likelihood of confusion and therefore there was infringement. Similarly, Orkin, the exterminator company, sued Orco, who also is offering exterminator services under that name. And again, the sound and sight are somewhat comparable, but not quite as stark as you saw in the Teflon example. However, there does seem to be a very similar commercial impression between Orkin and Orco. And again, the services are identical, so the court did find that there was a likelihood of confusion in this instance. Another example was the Cyclone fencing people who sued Tornado, also using fencing. Now, cyclone and tornado don't sound alike, they don't look alike, but they have very similar meanings. And since the goods were identical in this case, the court again found that there was a likelihood of confusion between cyclone and tornado. Another instance had Olay Cigars suing Olay for tequila. Now, in this instance, the marks are identical. However, the courts looked at the goods and found that these goods were not related, such that the public would be confused and think that the Olay tequila people must be the same as the Olay cigar people. Looking at how tequila comes through the marketplace versus how cigars come through the marketplace, there's just a very different type of nexus and origin of these goods, and the court was not concerned that there would be a likelihood of confusion, so no infringement was found in this case. My final example I have, down at the bottom of the page, there's the logo for First Bank System. A company was using that mark in connection with banking. And to the right of that, there's the First Bank logo, also obviously used in connection with banking. There's very similar sounds, First Bank being in both the marks. However, there's a much different sight between the two, and the commercial impression as a whole is also fairly different. So the court found that there was no likelihood of confusion between these two. I think also relevant to this is the fact that First Bank System is very descriptive. There's no original concept. There's nothing that really identifies a very specific bank as some other more imaginative types of names do. So hopefully that'll give you a feeling for what the likelihood of confusion test is and whether or not there is an infringement. A trademark is protected for as long as the user is using the mark. Once it becomes abandoned, the rights are gone. A registration, however, lasts for 10 years and can be renewed for successive 10-year periods. Now, this sort of underscores the difference between use and registration rights. It's common, matter of fact, almost impossible for a registration to occur before the common law rights occur. So people often, like Starbucks, are using the mark VIA long before a registration is issued for that. And similarly, the registration for VIA might expire while Starbucks is still using the VIA mark. Also, the other thing might happen. Starbucks might decide 3 or 4 years into the registration that VIA is not the right brand for them, and they'll drop it. But the registration will stay live for a long period of time after that. So registration of a mark does not mean that there's rights in it, and lack of registration does not mean that there are no rights in a mark. Trademark owners need to be very careful about licensing marks, that is, allowing other people to use their marks in connection with goods and services. The underlying public policy behind trademark is that the public can quickly see a mark and understand the nature of the goods and services, and specifically the quality of those goods and services. So if a trademark owner wants to continue to preserve the rights in their trademark, they need to monitor the quality of their licensee's use of a mark to make sure it's at the same quality level that the owner itself has been known for the period of time. Courts have several remedies available to them when their infringement is found in a trademark case. The most obvious is they can issue an injunction against further infringement so that the junior user, the second user of the mark, is no longer allowed to use that mark. They can also have an accounting for profits, which is just a fancy way of saying that any profits earned by the infringing party can be ordered to be paid to the infringed party. If the infringed party suffered any actual damages as well, those too can be paid to the infringed party. And in egregious or willful cases of infringement, those damages can be treble damages. There can be a forced seizure and destruction of the infringing goods, and in very bad cases, willful cases of infringement, the court can also order that the infringing party pays attorney's fees to the infringed party. It's worth going over who owns a trademark. It's fairly simple, but it's something that I think is worth at least discussing for a second. Ownership vests in the party that controls the nature and quality of the goods and services. Now note, this isn't always necessarily the same party that's providing the goods and services. There are many holding companies which have a lot of different marks, and the underlying companies beneath them are the ones that are actually using it. Or in some cases, it's a brand that's no longer being used by one company, but has started to be used, wanted to be used by other parties. So there's licensing going out, especially if you're going into different goods and services. So there's not always a direct connection between these two. And the creation of the word or symbol or whatever the actual trademark is not important. So if you have an employee creating a symbol, but you, the company, are actually using this mark in commerce, you're the owner of the trademark. However, as we're going to discuss in the other section of this, the copyright section, there could be some very important copyright issues at play right there. So just be mindful and cautious when you have an employee or an independent contractor, or a volunteer for that matter, creating your marks. And as I've sort of inferred along the way, when two parties are using conflicting marks, the one who is using it first wins. The senior user, not the junior user, is the one that wins, which is a good time to point out the fact that when you begin to use a mark, you want to be sure to do a search to make sure there's no one else out there using a very similar mark in connection with very similar goods and services, such that you become an infringer, because lack of knowledge or innocence is not an excuse in the world of trademark infringement. Also, be warned that a search cannot search everything, so it can't give you perfect knowledge that you won't be an infringer, but should give you an understanding of what risk you suffer, what risk you might be exposed to by using this new mark. Finally, I want to give you some hints on using your mark. The first is to use it distinctively. Make sure that your mark stands out on your web page and your materials and your advertisement, whatever. Different fonts, different colors, different typeface, whatever. Make sure they stand out. You'll want to give notice of your trademark rights. That's as simple for a federally registered mark as putting a circle R after the mark to the upper right-hand side of the mark. For an unregistered trademark, you can use a TM, or if it's a service that you're providing, you can also use an SM, your choice, but a TM always is good. Make sure to use your mark as an adjective. For example, don't FedEx something, have FedEx overnight courier services. You want to make sure that you're not turning your mark into a noun or a verb. Affix your mark to the goods or services. That's just a fancy way of making sure, of saying that you need to make sure whenever consumers are using your good, they see your mark associated with that. Or similarly, when you're out there providing your services, that your mark is somewhere in close connection with that service, so people understand the source of the good or service. And finally, as I've discussed already, be sure to license with care. I hear a lot of common concepts out there about trademarks that I thought I would go over and discuss quickly, because a lot of you probably came into this presentation with this as your only knowledge of trademarks. So let's discuss them briefly. The first common concept is that a domain name is always a trademark. Wrong. A domain name is not a trademark. A domain name is nothing more than an address or a phone number, or another way for a customer to understand how to get to your goods and services and how to connect with you. However, you want to make sure to be careful when you're choosing a domain name, because domain name law and trademark law does overlap. Specifically, you want to make sure that you don't choose a domain name that obviously refers to a federally registered trademark or any trademark in use, especially if your business has no connection with that. That's a very deep area of law, but I just want to warn you about that briefly. Another common concept is that searching a mark ensures you won't be an infringer. Wrong. It's not an insurance policy. At best, what it's going to do is give you a better idea of what risks are associated with picking a mark and using a mark. As I said, it's impossible to uncover all uses of a mark, because someone might have a sign in the middle of Iowa using their mark, and there's no way that a trademark lawyer or any other person could discover that use. My mark is different, so there can't be a conflict. Unfortunately, there can. As we discussed already, the test is similarity of marks. If any of you are Eddie Murphy fans, you might remember the movie Coming to America, where one of the characters owned a McDougal's hamburger stand, and the McDonald's people were always coming after him, trying to shut him down. Didn't see the end of that movie because it stopped too quick, but I think that the McDonald's people would eventually win that one. Another common concept is that registering a company name with the Secretary of State keeps other parties from using your name. Again, wrong. Obviously, you need to register your name with the Secretary of State for the Secretary of State to know how to refer to you and what names you're going to be using on your forms and how to identify you. However, they don't control what goods or services are sold in the state and under what marks that company is selling those goods and services. So there's no connection whatsoever between a Secretary of State filing and a trademark filing. Final concept out there is that you can register a common word, then charge a fee every time someone uses it. Well, if only it were that easy. Trademark, as I said, is a monopoly that's limited to your use in connection with related goods and services. So regardless of what your name is, you can't prevent others from using that name. There's also a whole host of fair use reasons that people can use a name to compare services or providers, etc. I'm going to conclude the trademark section by going over a hypothetical that hopefully will help you understand how some of these concepts come out in real life. I'm going to read from the hypothetical. Atlanta Heart Care, Inc. is a 501c3 formed in 2005 by Susie Cares. AHC's mission is to bring awareness regarding cardiopulmonary diseases and common risk factors. Prior to founding AHC, Susie was associated with Boston Heart Cure, a well-known not-for-profit Massachusetts-based healthcare clinic focusing on treatment of heart issues. So the first question, hopefully obvious to you, is are there any issues with the name that Susie chose? Well, let's go through a likelihood of confusion analysis. We've got two different marks, Atlanta Heart Care versus Boston Heart Cure. Both of them are simply name of a city the word heart, and then a very similar word after that, care and cure, with only one word being different. I would argue that these two marks are very similar, and when you look at the goods, one is talking about providing information about heart disease, cardiopulmonary issues, and the other one is curing heart disease. These again are very similar services, so I would caution Susie that using Atlanta Heart Care might be problematic. However, one's in Boston, the other's in Atlanta. There's not enough facts here to go into it, but it's very likely that Boston Heart Cure can only protect the use of its name in Massachusetts or however far out its goodwill might go to, and it likely does not come all the way down to Atlanta. What have we found out? That Boston Heart Cure, in fact, had a federally registered trademark for its name. Well, that would change my analysis quite a bit, because as I mentioned to you, a registration expands the zone of protection from just the use area to the entire jurisdiction. The United States obviously covers both Massachusetts and Georgia, so my analysis would change. There's a little bit more to that, but just for the purposes of hypothetical, you can see how that plays out. What if we found out that both Atlanta Heart Care and Boston Heart Cure were Delaware corporations? As I mentioned, Secretary of State filings have nothing to do with this. The Boston entity is using its services in Massachusetts, presumably. The Atlanta company is using its services here in Georgia, so there is no overlap and no connection. This is a relevant piece of information. What if we found out that Boston Heart Cure folded in 2003? Maybe that's why Susie moved from Boston to Atlanta. I don't know. Well, if that were to be the case and no other party was using the name after them, it's very likely that Boston Heart Cure would have abandoned its rights to the trademark, and it'd be fine for Susie to begin using Atlanta Heart Care here in Atlanta. Another trademark question is, could Susie's Atlanta Heart Care site have a link to the Boston Heart Cure site? I warn you against putting links on your websites to other entities, because it could show evidence of some endorsement, affiliation, or sponsorship between the two entities, and could be evidence of infringement. If you do want to use links on your website, I warn you to do one of two different things. First, get permission from the other site. If they say it's okay, I advise you to get it in writing, of course, being a lawyer. But if they say it's okay, then it's fine. Just make sure that you understand what your uses are and that they're fine with your exact use of their link. The second way is on your website to make it clear that there is no connection between the two companies, that you're providing it solely as information for your visitors to your website, and go to links to even say that you take no responsibility for what's on their website. It's just simply a service to your web visitors. Also important in this is when someone clicks on the link, make sure they go to the top of the other person's website. You want to make sure that the visitor is fully aware that they've gone to someone else's website and not somewhere deep buried in the text where they think, well, possibly this is still the Atlanta Heart Care website. So those are two different ways that if you feel you must have a link to go about that. A final trademark issue is, could Atlanta Heart Care acquire the domain name heartcure.org? Well, I mentioned to you that there's an overlap between domain name law and trademark law, and I would say that Boston Heart Cure could stop other parties from acquiring the domain name bostonheartcure.org, whether it has spaces in between it or however you want to do it, or a funny spelling. Any of those instances of Boston Heart Cure probably could be stopped. This is close enough that I would advise Susie to go a different direction, to not acquire that domain name, but that's sort of the analysis that you would go through, comparing the domain name to the actual mark itself. That's the end of the trademark section. I'd like to pause for a second and see if there's any questions that have been submitted or otherwise out there.
You talked about trademark search. Can you explain what that is and how you do it?
Certainly, a trademark search, there's multiple ways to do it. The simplest way is for someone who's familiar with the USPTO website to go to their website and see what registrations are out there. But I mentioned to you that registered rights and use rights are two different things, and a registration of a mark doesn't necessarily mean that there's no protection, or that there is protection of it. So you probably also want to do some simple web searching to make sure that you can't find others out there doing something very similar with a similar name. That level of search is usually called a knockout search or preliminary search. There are more advanced searches out there as well, most of them involving third parties that provide reports to us, and cost is usually associated with this. Most pro bono clients are only responsible for out-of-pocket costs, so I warn you that when you go to a full availability search or a knockout search, there almost certainly will be fees involved with that.
Says, can the circled R only be used for federal registrations, not state?
That's correct. It cannot be used for state registrations. There are some other uses of a circled R that belong primarily to registrations from other countries that are coming to the United States, but there are a lot of hoops to jump through, so for our purposes, let's just say only federally registered trademarks and certainly not state registered trademarks.
That's all right now.
Okay, great. All right, moving on to copyrights. All right, trademarks, talk about brands. Copyrights are mere expression sort of thing, so they don't necessarily have to be used in commerce or anything. A copyright is a limited monopoly of an expressive work. They generally cover the expression of literary, musical, choreography, and other artistic works. However, anything that is in writing or somehow otherwise fixed falls into this category, and businesses specifically run into this with their advertising text and things like that, and always have. But in the last 30 or so years, they've also found that software source code issues come up as copyright issues quite a bit as well. So there's a couple different reasons to be aware of and concerned with copyright law. There are 3 requirements for protection of copyright. Originality, which means that the author who developed the work, it must be original to him. He didn't copy it or see it from someplace else. Authorship, that's simply saying that there must be some minimal level of creativity involved. And finally, fixation in a tangible medium, which means it just simply must be recorded someplace, whether it's being on a piece of paper, in a computer, hard drive, wherever. Also, I want to go briefly on originality and mention that it's possible for 2 people to develop the exact same thing independent of each other, and both of them own a copyright in that. So original creation is always a defense. However, if you've been exposed to something and then create it, no go. All right, turning now to the slide 15. Registration is not required to protect or prevent copying. However, it is required if you want to enforce your rights in court. Now, copying I use simply because copyright simply thought of as protecting copying, but it protects more than that as well. It protects the performance, the display, the reproduction, the distribution, and any derivative works that come from an original work. The protection of a copyright is very long. It's the life of the author plus 70 years. Now we'll discuss work made for hire in just a second, but in terms of duration of a copyright, just keep in mind that if you're dealing with a work made for hire, the duration is 95 years from publication, which is most common, or if you don't publish the mark, then, or publish the work, excuse me, it's 120 years from the date it was created. And notice of copyright is not required, but it is encouraged. We'll discuss what notice for copyright means in a few slides. Unlike trademarks, a copyright owner can freely license its work to licensees. Now, there are many ways that someone can use a work. Obviously, they're the owner, they can use it. And by using a work, I just simply mean whatever, for example, text has been written or whatever. So if you own the work, obviously, you can use it. If you've been granted a license by the owner to use the work, you can use it. You can also have a fair use of a work. And that's one of the 2 big things that come up in copyright law, so I'd like to discuss that for just a second. A fair use is your use of another right, of another work in a way that doesn't infringe on their rights. And it's sort of a complicated analysis, but I'd like to go through it very briefly. Courts look at 4 things. First, they compare the purpose and the character of your use, the quote-unquote potentially infringing use. If your use is driven towards profit, you're probably not going to be able to use it. However, if you're doing it for educational purposes, if you're doing it as criticism, if you're doing it as some sort of other research, something like that, that would be potentially usable as a fair use. The second thing looked at is the nature of the work that you're copying. If it's informational only, you probably have more rights to copy it than if it's a truly expressive work. The third item is the amount that you take of the work. So if you are copying 100% of a book, you're probably not going to be able to get away with that. If you're copying a small amount of the book and you're not taking the heart of the book, you're not taking the punchline of the joke, you're not taking the very thing that makes the work what it is, then you're probably going to be okay. The fourth thing is the effect on the marketplace of the work after you have your use. So if after you use your work, you have this fair use of the work, would the original thing still be able to be sold at the same level it was sold at before? If so, then you're probably okay. Now, the hypothetical will go over this a little bit as well, but I just wanted to give you some understanding of fair use because it is pretty common, especially in the world of pro bono and not-for-profit clients who often borrow from one another. A final way that you could use a work is under a compulsory license. We probably don't have any instances of that, but one that you might be familiar with is the digital performance right in sound recording, which allows radio stations to play your favorite songs and just pay a few pennies for each play. Courts have several remedies available to them in copyright infringement cases. The most obvious is an injunction against further infringement. Also, they can demand or order the destruction of infringing articles. They can order that actual damages to the infringed party be paid. So whatever damages, goods weren't sold, for example, by the party that had been infringed, they could get that. But the big one that you see often in copyright law is statutory damages. If you infringe the work of something that has already been federally registered, the copyright has been registered, instead of them proving what damages they suffered, they can ask instead for statutory damages, which range from $500 up to $250,000 per infringement. I hope that catches your eye because it's certainly something that you need to think about, and especially in the world of copyright where innocence is not a defense. So putting your songs, your favorite artist song on your website, not a good idea. Turning now to the next slide, slide 17. Ownership of a copyright is a little more involved than ownership of a trademark. Obviously, the author of a work owns the copyright, so you go home tonight, you write a poem, you hold the copyright in that poem, nothing else required. Non-authors, however, can only hold a copyright if it's been assigned to them or if it's by a work made for hire. Work made for hire is a fancy way of saying you asked someone else and paid someone else, or maybe in the case of volunteer, asked someone else to do something for you. A company can't be an author. They have no arms, no legs, no head. They can't write books. They can't do these things. So companies cannot be authors. So this directly applies to the pro bono clients out there. A work made for hire, there's a presumption in the law that employees create things for their employers. However, independent contractors, not employees if you will, which also could include volunteers, create items for their ownership. And you have to do something to overcome that presumption. So with employees, any work prepared by an employee within the scope of his or her employment is considered owned by the author. So your employee too can go home tonight and, assuming their job is not to write poems for you, can create a poem and they own it. However, while they're sitting at your desk doing your work that you asked them to do, any text that they write or pictures they take or whatever become your ownership. Non-employees, however, have a very different analysis, and you need to make sure that, first of all, you specifically request the work to be made, that you have a writing that expressly says that the work is, and it's important to have these words, a work made for hire. Unless you have all those things in it, things created by volunteers or independent contractors will not be owned by your company unless you wind up getting an assignment later from the the author to you. We have a few hints for copyright use. The first, as I discussed earlier, is to put a copyright notice on every instance of publication. So every time you pull that text out, put it in a new flyer, new brochure, your website, etc., make sure you have a copyright notice. It's very simple. Down at the bottom of whatever item it is, write copyright, circle C, the date, and the name of the person claiming the copyright. So it's really simple to do, but important that you do give that notice. We have a question. Yes?
Does that date change as you use it from year to year? Or is it the date you actually originally created it? Or if you modify it, does it change the work?
The question involves the date and what date you should use, whether it's the date it's created, the date you are using it, the date it was changed, etc. Great question. If you're using it in an unmodified form, so the thing that you wrote in 1995, you've just pulled out and you've used it again and again and again, use the old date, the 1995 date. However, if you do modify it, and especially in some meaningful way, you didn't just change a typographical error, realize that a fact was wrong, and then just simply changing something very minor about it, I would make modified versions using the new date. But reuses of that, you always go back to the date that was created. I also recommend that you register your copyright material. Now this, unlike trademark, is very inexpensive. The current rate on the copyright website for filing an application online is $35. Now, unlike trademark, you probably have a lot more works that you'd like to protect, but for those items that you feel are really important to your company and your mission and things that you really want to make sure have protection, I would highly advise that you get registrations for these copyrights. Very simple, very cheap. And finally, as I've suggested, be careful when volunteers, employees, or contractors are creating copyrightable material. You should have standard language in all your contracts, even your employment contracts, that works created are work made for hire. Identify, especially if you're dealing with an employee or an independent contractor on a specific mission, identify what the work is, or at least the scope of what the work is. And you probably also want to have in that same contract that to the extent it's not a work made for hire, that the person assigns whatever rights they have to you. So you sort of catch it both ways. Either you do it by the work made for hire provision or by the assignment provision. Okay, a few common concepts of copyright. Just like trademark, I hear a lot of things floating around out there, and you probably have as well, so I thought I'd go over all of these, or at least a few of these. The first is that attribution will insulate me from liability. That's simply saying I use a Robert Frost poem on the front page of my website, but I tell you it's a Robert Frost poem. No, that is not going to protect you from copyright infringement. Really all it does is it helps Robert Frost's heirs realize that you are in fact copying from him, that this isn't something independently created or whatever. So while it's nice to give attribution, I'm not discouraging attribution, I do also at the same time encourage you to get permission from the copyright owner to use copyright work. Second concept is, if I change 10% of an existing work, I hold the copyright. By the way, I don't care what number it is, 1% or 99%. The answer is no. Once you begin with someone else's work and you start changing from that, you're doing nothing more than creating a derivative work of theirs. Now you can start with their idea and have your own expression, and you will own your own expression. However, once you start with their expression and you start tinkering with their expression, no, you won't own the copyright in that. Another concept, if I find it 5 times on the web, it's in the public domain. Again, that 5 can be 1, 5, or 50, and the answer is no. The public domain refers to things that no longer have a copyright held on them. As we discussed earlier, copyrights for a period of years. It's the life of the author plus 70 years. So Gone with the Wind, still under copyright because Margaret Mitchell didn't die that long ago, even though it seems long ago to us. And the fact that you find it a lot just means you're joining the list of infringers possibly. And it might be evidence that this particular copyright holder doesn't go after infringers, but if you like playing the lottery, go right ahead. Finally, if I don't charge for the work, it's not a copyright violation. As we discussed with the fair use provisions, there is some element of that. However, you're looking at infringing but finding a use for an excuse for infringing, and I would advise against that. Whether you charge or whether you don't charge for showing someone else's copyrighted material, it still can be copyright infringement. I'd like to pick up with our earlier Atlanta Heart Care hypothetical and see what copyright issues apply to Susie Care and her entity. First thing is, are there any issues if Atlanta Heart Care uses some text from brochures written by Susie while she was at Boston Heart Care? Well, we don't know if she was an employee. We don't know if she's an independent contractor. We don't know if she's a volunteer. We don't know what writings, contracts were between Susie and Boston Heart Care. So there's a lot that we need to know here. But generally speaking, if she was an employee of Boston Heart Care, the text that she created most likely belongs to Boston Heart Care and therefore cannot be used by Atlanta Heart Care without the permission or consent or a license from Boston Heart Care. So in that case, then I would say most likely Atlanta Heart Care cannot use those works. However, if Susie was a volunteer or independent contractor and there's no express writing saying that Boston will own the work, then sure, Susie probably could she would own the copyright in it, and she could allow Atlanta Heart Care to have the use of that. What about items written by volunteers? I think I've discussed that at length already. Again, this is a work made for hire issue, and a volunteer is not an employee, so a volunteer will not automatically have his or her work assigned to the not-for-profit. So unless you have some sort of assignment or otherwise a work made for hire specific document written up, then Atlanta Heart Care will not own the copyright. However, the law will probably assume that a volunteer writing something for a nonprofit at a minimum is giving a limited license to the not-for-profit to use it for whatever purpose they had. So you're probably okay to use it, but you don't have the full range of use that you would want to have or that you think you might have. And I would probably get, in either of these instances, an attorney to look at the facts to determine what rights you might have. Now, separate from whether or not they can use it is whether or not they own the copyright. I think I discussed that a little bit, but generally you want to make sure that for Atlanta Heart Care to get the ownership of this, that either there's an assignment from the original copyright holder to Atlanta Heart Care, or there's been a work made for hire document prepared at the time that the work was actually done, showing that the work is owned by Atlanta Heart Care. Are there any issues if AHC posts pictures of its annual fundraiser on its website? Wow, there are a lot of issues with pictures of people. First of all, you have the copyright issues of the photographer. I don't care if the photographer used his or her camera or they used the not-for-profit's camera. The person using the camera is the one that owns the right and the copyright. So first of all, you need to go through the analysis to make sure that the photographer is okay with you using the picture. Secondly, you're taking pictures of people, and this is not a discussion on rights of privacy, but just know that you need consent of individuals to post their images, especially if they're taken in a private setting on the website. There's some consent forms that you can get from your attorney or contacting Pro Bono Partnership to make sure that you have the type of rights that you need right there. And what if you're using a song on your website? Are there any issues with that? Yes. There are issues with that. Do not have songs on your websites. Do not have other people's pictures on your websites. But let's assume for a second that it's not just any song that Susie puts on her website, that it's the song Stayin' Alive by the Bee Gees. I don't know if any of you realize why I chose that song specifically. I'm not a disco fan myself. But I did read some articles back in the summer that said that several heart entities said that the beat in Stayin' Alive is the correct beat to use for CPR. So if you're using it for the purposes of educating people and letting them understand the right beat for CPR, then possibly you fall under a fair use exception. So I said I'd go through a fair use analysis for you. So Stayin' Alive is a creative work. It's not an informative work. It's very creative. And you're taking the whole thing. You're not just using a snippet of the song. You're using the entire song. So those two factors really weigh against you. However, you're using it to educate people. You're really using it for a different purpose whatsoever. The Bee Gees, I don't think were thinking about CPR when they wrote that song. They were thinking about the next hit, I believe. And you're going to have, your use of the song will have very little, if any, impact on the Bee Gees' ability to continue selling Staying Alive albums. I imagine it's not much right now, but whatever extent they have, you're probably increasing it in some way. So while it's an arguable position, I do think that you could have a fair use argument of using the song Staying Alive in this very limited instance of the heart care situation. All right, well, that concludes the materials I prepared for this presentation. I'd like to stop for a moment and see if anyone has any questions.
Are there any online?
No questions? Well, great. Well, I'd like to point you guys, if you have any more questions or need more information, be sure to call the people at Pro Bono Partnership of Atlanta. You can contact them by phone at 404-407-5088 or by fax at 404-853-8806. You can also send them an email at info@pbpatl.org or visit their website at www.pbpatl.org. Thanks and enjoy yourselves.